Hello, everyone, and welcome to today's CDCT live session. My name is Jason Rader, and I'll be your host for the next few minutes. Today's topic is the role of legal in incident response, and we've got some previous folks who've got us up to this point in this topic with us today. We have Doug Martin, who heads up our incident response competency, and Jeremy Nelson, who's the Director of Network Services here in CDCT. Welcome back, gentlemen.
Hey, guys.
Thanks, Jason. Great to be back.
So, guys, I think we're going to have a rather lively conversation today. There's a lot of stuff, and we had actually I tried to get some legal counsel on here with us, but they were probably smart in not accepting the invitation. So we should probably kick this off by saying none of us are attorneys. Is that fair to say, gentlemen?
Very fair.
Yeah.
Just checking in case something happened over the weekend.
I was going to say, I don't even play one on TV.
Okay. So, although we're giving you guidance based on our experience in situations, you should never take this advice as the exact advice that you should follow in any legal situation. So, with that being said, and our attorneys passing off on that, let's start off. I think, we've got tons of stuff to talk about. It might go 6 hours, but I doubt it. But when we're talking about this stuff, I think there's, we got NIST, we got Health and Human Services, we got PCI, we got all of these things. Let's kind of kick that out there. Who is in charge when we're talking about incident response and breaches and incidents and those kinds of things?
Who's in charge?
Well, who's it's a trick question. Like,
Okay.
There's nobody out there that's like the definitive answer for you, depending on all things. Is that correct?
I thought you were, actually.
Well, besides the guys on this call, right?
I think it comes down to, sorry, Doug, go ahead.
No, go ahead.
I was just going to say, trick question, obviously identified now. There's a lot of people, there's a lot of different roles, there's a lot of different agencies that have a part to play in this. I think is really where you're going, right, Jason, is that we've got a law enforcement aspect to this. There's a Department of Justice aspect to it. There's regulatory, state, different compliances. So I think there's a lot of folks with a lot of interest in helping to set best practices, legal precedent as far as IT and digital security goes. So yeah, that's again what Doug was joking about there, right? I don't think anyone's in charge. I think there's a lot of cooks with their hands in the pot, but really at the end of the day, it comes down to individual leaders and IT and security specialists within the organization that really are kind of the owners of that. They have responsibilities to other folks, but I think they end up being the owners. That's my take, at least.
Yeah, I agree. It's kind of a Rubik's Cube when you try to figure out, who do you notify when and how. It's something you want to do before you have an incident, and not during or after, because there's certain regulations and certain contractual obligations have really strict time frames. So when you enter into an incident, it's amazing how fast it goes. 2 days just blows by. So,
no, and you guys nailed it. I think that.
Sorry, Jason.
Sorry, Doug.
No, you can.
Well, I was going to say that you guys nailed it. It's one of those things that this, to your point from one of our previous sessions, Doug, it's, if you got the fire truck out there, you don't want a whole bunch of people trying to read the manuals when the fire's going, right? This is not something when you're talking about the legal aspects of privacy, of the state and local, laws related to disclosures not disclosures, notifications of those people whose information has been disclosed. All of that stuff is something that you, and when I say you, I'm talking about you with your legal counsel, need to get sorted out beforehand to know what you're on the hook for, and to deal with that. Because at a certain point, I used to say this a lot, I haven't said it in a while, but security, when we're talking about it in this particular aspect, is about liability to a large degree. And what you're liable for. And I'm not trying to say, I think a lot of these laws are on the books, both federal, state, regulatory from different industry, are because folks have done stuff on purpose that has gotten folks into trouble or taken advantage of certain classes of folks. And that's why all these things are out there. So I have to believe that all of this stuff has been enacted to protect individuals and their privacy. But it gets to be such a crazy amount of stuff that's got to be coordinated and dealt with just to be able to operate in the United States in general.
Yeah, what a cool thing to talk about here, Jason. Just a couple of things off of what you just said there is when you were talking about that, the fact that a lot of these guidelines, a lot of these regulations exist because somebody did take advantage, or but chances are there's somebody on the other end of that. Usually, when there's someone that's taking advantage, there's someone who's just not aware. And
Yep.
I always think about this. I believe, I hope I'm going to cite this correctly, my source here, but I believe it was Jim Gaffigan who talks about the instructions that are printed on a Pop-Tart, right? On the Pop-Tart wrapper, that you're supposed to take the Pop-Tart out of the wrapper and that the contents are hot. Like, I don't know if any of you have ever taken a few minutes to actually just read through the instructions for a Pop-Tart, but it feels very, very similar, right? It seems like it for someone in the know and who has the information and the wherewithal to understand what's happening, it's common sense, right? But for someone who doesn't and goes through or takes advantage of the fact that it's not printed on there, does something, hurts themselves, and then makes somebody else liable for that. It's very similar to what we experience, I think, in the IT security space as well.
Yeah, I think from the get-go, you have to figure out a plan to create a defensible position for your company. So if there is any kind of litigation or anything like that, your attorneys have the best are in the best position to manage that. You certainly don't want to do anything to unnecessarily harm their or your position from a liability perspective. And it's remarkably easy to do that. I mean, there's some key things that I think that companies do or seen done over and over again that really did not help them from a defensible position perspective.
Yeah, and it's go ahead, Jared.
Oh, I was just going to say, and on that position, Doug, right? Like, words matter. I think that's another interesting
That's where I was
one,
going.
right? Oh, I'm sorry. Then I'm not going to steal your thunder, Jason.
No, I'm just patting you on the back for taking us there, brother. Keep going.
So a couple of things that just words that we've used in the opening kind of just couple minutes of this conversation, right? So Doug, you're very explicit on using the word incident. In fact, if we go back and the previous conversation we had on this topic, it was all about incident response, and there are certain words that we specifically avoided using. And I think that's something to recognize, again, that words have meaning. And in these types of situations where security, data, risk is being involved, those words that we use, if we don't use them appropriately, can really come back and harm us from a defensible position perspective, Doug.
Yeah, like the word breach has legal implications. So,
yep.
You want to be very careful with that when you're in the middle of an incident, when you're working it. Email, you got to figure everything that you say, write down, email, text, whatever, it could be discoverable later. And so you don't want to say, hey, we had a breach, especially on the security team or in a position that maybe, viewed as a position of authority around or expertise around that specific space. Because the only person that I ever would talk to you about a breach or make a determination is your counsel. There's very specific laws and regulations in all different states about what actually a breach is. So I really try to stay away from that. I'm kind of a stickler about that. I never want to have anything I do later come back to, to the detriment of one of our clients potentially.
Yep.
And I think
again,
keep going. Please.
We're good. We're clearly on the same wavelength here, Jason. Like, there's something that's tuning us in together. The same shirt, exactly. I was just going to say, very similar to that is, and now we were talking about shirts, and I lost my train of thought. You know what? Move
on. Well, in an effort to kind of keep the folks that aren't security experts following what we're talking about. So Doug and Jeremy, you both pointed out like incident and breach. Somebody, Doug, Jeremy, give me the definition of incident versus breach.
Man, we are perfectly in sync. That's exactly where I was going. Going back to that first comment around who owns it. You talked about NIST and some other of these guidelines and things that industry standards that have been set up. NIST doesn't actually define a breach. Like, it's not specifically called out in NIST on what a breach is. So we have to actually go external to that to get other either legal or IT definitions for what classifies a breach. And so anyway, I think that's really interesting. Keep me honest here, Doug. I'm going to give my 2 cents on breach, and then you can come in and fill in the gaps. But basically the way that I interpret and communicate what a breach is, it's anytime you lose control of impactful data. Right. So anytime that you have, whether it's sensitive data of any nature, and you either lose control of it, whether that's through access, whether that's through unauthorized access, whether that's through exfiltration, anytime that you are no longer fully in control of who has access to that data, that's typically how I communicate a breach has occurred.
Yeah, I think that the big difference is it's a determination. It's a legal determination. So some states, one data element, for instance, will get will get you where you have to notify. Other states, it's multiple. Some states have a minimum amount of records that need to be compromised. Some states give you a pass for if you have the data encrypted. Some don't. How you encrypt it, the level of encryption. There's all kinds of. It really is a Rubik's cube when you sit down and try to figure that out. So I mean, I look at my position as I provide the facts to the attorneys. Inside and outside counsel, and then they make the determination. I would never even try to step into that. Once that determination is made, then that triggers other events around holding onto that data, potentially notification, obviously, preserving the data. It changes everything changes as soon as it's declared a breach.
And
I think
that's a great point, because let me just finish this one, Jerry. So.
Go ahead.
What I was going to tack on to what Doug was saying is that means that the definition of breach has to be part of your plan. Here's what happens when we declare this to be a breach, and that's declared based on the plan and based on the folks that are responsible for declaring it organizationally. And then once it's declared, that word can be used. Using it beforehand, to both of your points, is something that is not suggested, because that implies a certain thing that has not been declared based on the plan so far.
Right. Yep. Yeah, I think one of the big things one of the big pieces as well is your initial purchase order or statement of work agreement with whoever, with your outside incident response partner. I would highly recommend that come from counsel, or at least check with them first. Many reasons, but one is potentially preserve privilege. If that statement of work doesn't come from them, then it may not be viewed as legal work product. Making determinations of any kind, I think you have to be really careful about any kind of incident response. You want to have an attorney. A lot of the responses I've worked, you actually have a specific meeting around determination. So you produce facts, and then you bring them to that meeting, and the determinations are made about, was the record compromised or not compromised? How was it compromised? All that. So get your POs cut from legal if it's possible. I would recommend, but ask your counsel.
And I think that comes back to similar, like what we talked about on our original incident response conversation, right, Doug? Is that that was I think a extremely important thing that you brought up, is that you have to build a plan, but it's not an IT plan. Like, this is just as much of a risk legal issue as it is anything else, and making sure that either your counsel, internal or external, is involved in that planning, and knowing when to get them involved and how to get them involved.
Absolutely.
Yep. I think another interesting thing that we kind of, again, coming back to the words matter topic that we were that we were just kind of touching on a little bit there. Yeah, I think another thing that I've picked up is that we're all being very, very explicit in the way that we're using certain terms around communication, right? I think that, when we kind of break that down, you have, notification, which is typically letting a broad set of people who've been impacted by an incident, making them aware that something has happened. I think you then have like the disclosure side of things, right, where you're having to get different state, local agencies involved with letting them know what has actually occurred. And then you've got the big one whenever we get law enforcement involved, and now we're getting into that reporting aspect, right? So I think there's, again, words have meaning, and I think the more that you're aware of that and conscious of what some of the terms you might be using, how those could be interpreted. Doug, coming back to your comment, right, that everything's discoverable, that could have a significant impact on the outcome and how you and your organization are potentially found responsible.
Absolutely.
Man, this sounds like a lot of stuff. Again, some stuff that you can't figure out in the middle of while you're exposed to this type of situation. And from the again, trying to keep it for the folks out there that are relatively new to this topic. I think from a maturity perspective is why we hone ourselves down to that language that we use. That maturity comes from the organization being prepared and doing those appropriate tabletop exercises or other things to make sure that everybody's aware of the plan. But before we get into that, because I do think we should talk about that, let's talk about, just because somebody gets into your organization, it really comes down to, first of all, you need to know what kind of data that they had access to. I mean, just dumping all your data into a central repository, a big playground of blob of data, is probably something that makes your efforts on the back end of this much more difficult than knowing where the compartmented or the different data types exist.
Yeah, I would think during your pre-planning, you'd want to sit down with counsel and figure out, what kind of data do you have that's monetizable, that the bad guys would like to go after, or what kind of access, or it just depends on your business, and try to build out, what does that mean? Is it, we have it encrypted? Is it encrypted at the right level? I mean, there's a lot of things you can do before to create a defensible position from a legal standpoint, not only a technology standpoint.
Yeah, I love that. I always say I've been an expert witness before, and it's never a 0% liability or a 100% liability. It's somewhere in the middle, and it's all about how you present the way that you understood the risk that you were exposed to, that you did the due diligence and took the due care to protect that data. The worst thing that you can show, say in court or in a liability situation is, well, we were figuring it out as we went along. The best thing that you can say is, well, we took all the precautions, we followed the procedures, and still bad stuff happened. But that's a big swath of liability that we're talking about.
Yep. Well, I don't forget about the court of public opinion as well. So I know that we're focusing pretty heavily on on actual legal law, going to court, those types of things. But there's also that court of public opinion, where the way that you manage that communication, the way that your organization is tried and weighed, as far as whether that be through clients, whether that be through potential clients, whether that be through just your overall reputation in the industry, it could be at risk.
Yeah, I shared with you guys my favorite quote, my favorite legal quote. Legally speaking, hope is not a plan. And I think that combined with, if you do get into a litigation situation, a lot of people that are non-technical are going to be involved in that process, either presiding over it or some part of that journey. And I think you always have to remember that Jason's always pulling us back to. So for people that are not in IT or not in security, what does that mean? I think it's really important to understand that when you go through this, maybe at the end of when you do your lessons learned, about trying to frame it in a way that people that are not lawyers or technical people can understand. You may have to do that. You're probably going to have to do that. Somebody, CEOs and CFOs and such.
And, Jeremy, I think you mentioned it earlier. We're talking about, when we call law enforcement in or when that actually happens is definitely a pivotal point in the amount of control that you potentially have over the situation. Any comments related to that?
Yeah, I mean, we've all seen the police shows, right? So whether that's a local law enforcement working on a particular case and they lose jurisdiction, right? And then whether that be FBI or some other type of law enforcement entity comes in, your ability to then influence and direct the outcome of what you started completely gets taken out of your hands. And that's very similar to what we've seen with some of the incident responses that we've been involved in. And even then, even leading up to it, some of your actions immediately become into question. You're having to find yourself in a position where you're having to kind of go through and, hey, this is what we did, this is why we did it. And then even having to try and maintain some type of transition on being able to hand over your efforts to another entity that's now taking control. So yeah, it's obviously for those of us who work in the industry, not a great position to be in, to have your job being handed over to somebody else, especially in a law enforcement agency. It definitely doesn't give us a lot of good footing to stand on as far as after the event is completed. But again, it just also makes it so our ability to influence the outcome is more limited.
Yeah, I think the worst scenario there is when they come to you and tell you you've had a breach, or sorry.
Oh yeah. Oh yeah. Oh
Incident,
gosh.
right? And that's unfortunately. I mean, I think the stats like still 65% or 70% are notified from external agencies, Visa, MasterCard, different law enforcement agencies, and that's really is probably the worst outcome that you can have. I found in my career involving law enforcement has been a good thing. It's about the timing and when it's appropriate to do it. If you don't do that, it can get a little sideways. But I've had nothing but good experiences working with FBI and Secret Service stuff.
No, understood. And that's kind of what I was getting at. Just like when a breach is declared, when there needs to be a definition of when law enforcement comes in. And again, that is the right thing to do, but doing it at the wrong time kind of limits your ability to control the situation to a certain degree, to Jeremy's point. And I think for the uninitiated, I'm going to still kind of talk about this. The reason that it is not a great thing for law enforcement to come to you, because we're used to in most other situations, if law enforcement comes to you, they're helping, right? The fire department's going to show up because somebody said your house was on fire, so we're here to put it out immediately. That's not typically how security incidents go down when you're notified by a three-letter agency, right? It's because they've been watching things go down for a certain amount of time, not necessarily related to the amount of data that you've been hemorrhaging out. It's usually they're trying to figure out the actors who are involved, and you might be some collateral damage related to that.
Yeah, I think one of the scenarios that I hear about is that one of the clauses in most of the state regulations is if there's an active law enforcement event happening, and you can delay notification. They allow for that. And so I think that from a consumer perspective, I've never seen that play well. So, you're having an incident, law enforcement's involved, they're investigating, which they need to do. And you maybe need to not be you can't make it public yet, but the records are still getting, things are still getting compromised. There's still things going on. So when you go to notify and you tell people, it's 6 months ago, why didn't you tell us? Well, we couldn't because it's part of an investigation. This doesn't play well, usually in the press or the court of public opinion. So definitely the timing and, just finding your own incident is always best. Absolutely.
Gotcha. So, after all of this stuff that we've talked about, it's, when we talk about security, usually we're heavy on the technology side, right? When we're talking about cyber incident response plans and those kinds of things, a lot of people get really focused on cyber and go straight to the technology side of those aspects. What we are trying to impress on everybody, regardless of your experience from a security perspective or not, is this is not something that is easily handled in the fray, and something that's got to have a very significant amount of effort across the entire organization, involving legal counsel to define, educate, rehearse, and then work through and then figure out on an ongoing basis the legal regulatory requirements that you're under, because those could change at any potential, based on new regulatory requirements and those types of things. Fair enough, guys?
Mm-hmm.
Yep.
Any closing words? I know you guys have a wealth of information, but where should folks get started other than kind of the stuff I just rolled out?
I mean, reach out to your leadership. I think involve legal. Make sure that they're invited to meetings. I think ask them more often than not. If in doubt, ask them.
Yep.
And I think that if you're looking for outside counsel at 3:00 in the morning on a Saturday, probably not good. So, I mean, identifying, what part of your legal apparatus is going to own an incident is important as well.
For sure.
Yep. And I think just another throwback to one of the things that we talked about during our last conversation is just really coming together, working on that plan, right? At least getting the conversation started, whether that's you as an individual, from a technology specialist, from a leadership role, wherever you happen to be. If you don't feel like you're aware of the plan, reach out to somebody, figure out if there is a plan. If not, I would say be that catalyst for change. reach out to different, like Doug said, connect with your leadership and start putting together some type of an action plan to get a plan in place.
Yeah,
and I'd be remiss. Oh, sorry. Go ahead.
Go ahead. No, please.
I was just going to say, it looks like we actually had a question come in.
I couldn't read it, so yeah, please.
Yeah.
So,
and it's actually a very good question. We'd love to dig into it if you guys have a couple minutes.
Rock on.
So it came in. It's how should a technology specialist handle a situation in which the business executives are not communicating accurately about a security event?
So there's probably a legal answer. Yeah. There's probably a legal answer to that and a practical answer to that.
I think, my experience has been that the technology perspective and the legal perspective, laws are usually behind the technology. And so there's what qualifies as a breach and a notification of a breach from a technology perspective looks like it should be, maybe larger or more, or should even be a breach, but maybe it doesn't qualify from a legal perspective. So I think just understanding, making sure that, that what you believe is in line with the regulations and the laws, and then just, reaching out to your leadership and saying, this is my perspective. Why is this different?
Yep. Yeah. And I think, again, coming back to our previous point in this conversation is that if you're actively working with and legal is a part of that incident response team, chances are that executive might be getting coached on some of that verbiage that they are to use in these particular communications. So I think, especially as technology specialists, sometimes we get down in the trenches and we see a little too much, right? And we know that we've got our vision, we've got our perspective on what is happening and what the reality is, but there's a different level of communicating that to different audiences. And I would say, my I guess suggestion would be is take that first position of is our internal counsel involved, and are they potentially coaching this executive on exactly how to communicate this depending on the audience? And B, if you feel like it really is at an appropriate level, just like Doug said, connect with your leadership or raise that up to your legal counsel to let them know that you feel like there is a discrepancy in the communication versus what the reality is.
Yep.
Yeah, exactly. And I feel the exact same way. I think, one of the kind of caveats that we get into from a leadership perspective being on that side is that sometimes we're advised not to communicate back down to our internal folks related to some of the stuff, or we're told to kind of quell the communication because of the legal impacts of it. So we forget the internal folks who really need to hear what's going on, and they might not have the full story. But one of the things when you work for an organization, one that has C-level folks involved and publicly traded and all the regulatory stuff that's probably beyond your exposure on day to day, is we got to trust those leaders, right? We've got to trust that they've got it done. But I think back to an earlier point that you were making, Jeremy, is be that catalyst to go forth, because there may be two separate plans within the organization, not for a specific incident, but like overall, where legal has some stuff dialed in from a legal perspective, but it might not be making the connections on the technology side. And I think that's where there can definitely be a gap that is, we reach across the aisle and shake some hands. And that's the real transformation that I think we talk about with our clients.
Yep.
Absolutely.
Awesome. Well, gentlemen, it has been a fun time again. Thank you folks out there for the questions. That was awesome. And, we really have a great time talking about this stuff. We're really passionate about it. This is what we do day in, day out. And we understand what everybody out there has got to go through with these types of situations. We hope you really enjoyed the content today, and let us know if there's some other stuff that you'd be interested in hearing from us. Otherwise, please visit us at insightcdct.com for lots of other additional information about what we do. Thanks, and have a great day.
Thank you all.
Thanks all.
You're good.